Actually, as Navi said, it's an informal number one. And my interest is that we have gone through many times with Mr. Navi on dgpsi, DPDPA 2023, what it is addressing, and we had a multiple roundtables as part of our IDPS too, right? So I thought at least once in a month, one session, we will dedicate ourselves till this DGPSI is settled down nicely with us, number one, to start with, and with the industry, right? So instead of having a kind of training session again and again from Mr. Navi, I thought that each one of us, right, will go through the DGPSI. I know it is not easy, right, to go through 490 plus pages, right? But if we take one chapter or one session as we go along, whatever the problems we encounter, and then address it with Mr. Navi, specific questions on what is that particular component, believe me, in a quarter or 6 months' time, we'll be very, very confident of this DGPSI, and it will also really spearhead within the industry, is my thought process. So to start with, I discussed with Mr. Navi last week. I said that, okay, I will start with a few of the basic questions which we might have heard from him earlier, but still to strengthen our thought process on. So I prepared some questions. I'm going to put that questions to Mr. Navi. And he also told me on a lighter side before this call, oh, Ramesh, you are going to take, you know, because he is the one who has to put questions to us in the examination, very tough one. But I don't think I'll be able to put any which is not answer well, it's fine. So, sir, to start with, right, just wanted to understand that law August 11th has been, signed. We are all waiting for the Data Protection Board of India to be formalized and understand that the DPB of notifications or guidelines, etc. Right? That I think the DGPS what we had formed addressing where it's its, can I call this of practice? Can I this as a kind of measure? Before even the DP start thinking about notification of the shall or the required components of our act. Do you see this, but our framework, your framework rather?
Okay, I think your voice was breaking for some part, but anyway, I have tried to gather the essence of what you are asking. That is, presently we have the Act, and then the Data Protection Board is expected to come, and whether there will be changes in terms of what needs to be implemented between now and the rules. This is one of the things. Okay. Now, we have conceived this DGPSI, first of all, as a framework for compliance of DPDPA 2023. Okay. See, all of us, particularly practitioners, are used to using a framework as a guideline. Okay. Of course, if you are well versed in a particular thing, you don't require a guideline actually. You can yourself look at the act and then look at the compliance. But it becomes easy when you have a list of things to do in respect of any compliance of a legal, you can say, requirement. Okay. Now, people are used to ISO and other things also. So there is a kind of a reference framework. Against that reference framework, they try to make an assessment and then arrive at whether the position is satisfactory or unsatisfactory. So keeping that general framework in mind, we wanted to create a framework for DPDPA 2023. Okay, that is the first objective. Now, when the DPB is formed and rules and notifications come, they have to be only within the provisions of the Act. So the Act is now frozen. And what are the requirements under the Act is stated already in the Act. Plus, the Indian Act refers to the data controllers as data fiduciaries. And legally, when we say somebody is a fiduciary, we try to say that he is expected to be a trustee. In that situation where the personal data is considered the property of a data principal, he has entrusted it to the data fiduciary, and the data fiduciary has to ensure that the beneficiary's interest is taken care of. This concept is not there in GDPR, so that in GDPR, if I have a good consent, that is everything. Okay, I don't have to worry much because you have told me that I can use it for a particular purpose. I am using it for a particular purpose. But in the case of a fiduciary relationship, sometimes we cannot take that hard stand. One example which we can take is that of portfolio managers who are required to say manage the portfolio of a minor. Now, the minor may give some instructions. There is a trust objectives which state that you have to make money for the beneficiary or something like that. However, while taking a decision about the investments in the portfolio manager has to always keep the interest of the minor in question. He should not say, I mean, go by a decision to buy a particular stock because that company is known to him, or let us say he's getting a commission or something like that. So the moment you get a trusteeship, you have to actually assume a larger than direct relationship. Therefore, the act, what it conceives as the objective, which is the underlying objective is to provide the right to privacy of a particular person as per the Puttaswamy judgment. That remains as the fundamental requirement of this act. Therefore, I feel that we are today in a position to anticipate what is going to be there in the rules. Rules are going to facilitate what is required here. For example, one of the rules which has leaked out is government is thinking how to ensure that the minor's age can be queried and obtained. Okay, that is a procedure. Now you create an API, you use Aadhaar, whatever is that, is one of the procedures. But when we are looking at a framework, identifying a data principal, whether he is a minor or not, it is a shell component. Okay. Now, once you identify somebody is a minor, then ensuring that parental consent is obtained is a shell component. What Ramesh calls a shell component is must be done. Mandatory. So now I don't need this detailed law or the notification to determine that I have to put in place some framework for this. Okay. If I got a small company, I may currently all internet companies, what they are doing in the terms of in the conditions, they will have a statement. I am above the age of age where I can take my own contractual decision, something like that. I am not a minor, something like that is there. So it's a self-declaration. Now, that may not be perfect, but it is what is happening today in the marketplace. Now, you can say that is the base level which people are going to use in their privacy policy or privacy notice. They will perhaps put that kind of a thing. But the question comes, when you are reasonably expecting that the data principal could be a minor, then what additional steps you take to find out whether he is a minor or not? So India has got this Aadhaar. There is nothing better than Aadhaar because Aadhaar records the data and date of birth. So therefore, you can always take the Aadhaar number of the minor, or of course, instead of the Aadhaar number, maybe the proxy virtual Aadhaar number. Then you can capture a assurance from UIDAI about the date of birth. The person may have to declare that he is 17 years of age, 16 years of age. Your query to UIDAI will ask whether he is 17 years of age, and they can confirm. So you will have a perfect, confirmed date, okay, of birth. The same Aadhaar also has got the father's name or the guardian's name. So you don't have to run around. You can ask in that same form which you are asking the minor to fill up his parents' name, and that also gets verified in the Aadhaar query. So India is in a unique position to use Aadhaar in this particular issue. Of course, the Supreme Court decision on Aadhaar was that private companies cannot use Aadhaar for any of their services unless there is a separate law for that purpose. So that problem will still be there. And even when the government comes up with a notification, I think there will be a lot of debate on whether government is capable of providing that kind of a uh, 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 rules where you ask any data fiduciary to ask for Aadhaar and then go ahead and verify the date of birth. But government may say that, okay, it is mandatory to use virtual Aadhaar. That's one of the things they can do. They may say that use of real Aadhaar is prohibited. You have to use only virtual Aadhaar. But many people do not know what is virtual Aadhaar. That they have to learn something like that. But that may be one of the conditions they would be putting. Second thing is, as far as this act is concerned, is that there is a consent manager kind of a provision. So I can create, I'm saying from the government, if I am the government, I can say, I will make UIDAI or one of the let us say the agents of UIDAI as a special consent manager whose only work is this age determination and confirmation of minors, nothing else. Maybe that will also work. Now, what I'm saying is these things follow. Therefore, we are in a position to look at the framework
Right.
based on the act as of now. I think that was what Ramesh
Yes,
you
yes,
wanted.
yes,
Yeah.
yes. Now able to hear me, sir, properly?
Now I am able to hear you.
Okay, okay, great, great. Thank you very much. Absolutely. That was my question to understand. Now,
Somebody had some other question, I suppose.
yeah,
Somebody. Anybody?
Kamal Nath's question. Okay, I'll just ask you, what is the legal age required for a person to have Aadhaar card? Is it 18 or below? Is
No,
his
it
question.
is the parent will get the Aadhaar card even for a infant.
Kid. Mm.
Yeah, it is possible.
Yeah, yeah.
Yeah.
So, sir, taking that first question, so if I'm right, you are looking at the DGPS as a generic framework. Is that right? Which could be
It will
used,
start as a generic, the framework will be generic,
right?
but at the time of implementation, the consultant will have to create templates. Say now, you know that you have to give a privacy notice. You know what should be the contents of the privacy notice. Okay, now the framework will have to say only that. Now, then how do you write that consent and other things is a matter of detailing, which I feel will be the realm of the consultant. Okay, so even if you take your ISO 27001 or anything, you don't get one full paragraph of what needs to be done. You only get the title and
Yeah,
the requirement general description. So framework can only do that. Beyond that, I feel that the consultants will have to develop, and those consultants will have to look at the rules in greater detail, because they will have to actually ensure that whatever they create is in tune with the particular rules. There, the consultant will also decide about the risk aspect. So, for a company where the risk is small, he may use a simpler template. For a company where the risk is very high, he may use a more complicated framework, template. So that discretion again will come in the form of implementation, which the DGPSI consultant has to manage. Okay. At some
great.
point of time in future, we may roll out certain, say, draft templates and other things, but they have to be highly customized. So presently, I'm looking at that as something to be developed by the consultants.
I got it. I got it. So, bottom line is it's a generic framework, could be customized as per the business need or the context what we talk, right? About that particular sector or whomever we are going to implement it, right? There is a question from our friend Subraidu. What is the difference between minor consent under GDPR and Indian Act? Besides the age limit numerical value, process of obtaining the consent and retaining the consent, are they not the same? Saw MNCs create a fuss around this. Is there any substance to this, or are we missing something?
Okay, see, obviously, except that it is 16 years or 18 years, there also the parental consent is required. So what he says is correct, that the process should be similar. But anyway, there are practitioners here. Okay, you know what companies are doing. I said that sometimes companies simply ask for a declaration that I am not a minor and be satisfied with that. I don't know if you have anybody who is having a more rigorous verification, you can tell me. I remember that in the early days of internet, when this question was raised for Yahoo mail account, what Yahoo used to do was that they used to ask for a credit card number. Okay. And if somebody has a credit card, they were assuming that he is a major. Okay. This, of course, is no longer in use. And now we cannot ask for a credit card number because that could be misused. But this practice was in vogue maybe around 2002, 2003. I don't know how many of you remember that. I remember it exactly. It was being used by Yahoo for their mail accounts. So they used, like we are talking of Aadhaar today, they used credit card ownership as a determinant of the age. But after that, I don't think any of the companies are really taking efforts to get an assurance about the date. They are just going by the declaration. But when you have a service which is meant for minors, like say Byju's or some education service which is generally supposed to be used by students, you actually register students as a student of 6th standard, 7th standard for some this thing. Obviously, they have to be minor. So there has to be a parental consent. There is no option there. Okay. So I would like to say that there is no difference between GDPR and here this one. And I would like any of you to tell me if you have found any company following a system like what we are discussing, like Aadhaar verification, a third party government verification on the minors age and other things. I would be glad to hear that. My own impression is that nobody is doing that, but including Ramesh, anybody else can tell me if you have come across any such things. As Subraidu?
Yeah,
Subraidu,
sir. So 8 to 10 years ago, when my son was creating his Gmail account, so he first did the right way and he gave his actual date of birth. He was below 18, so he was rejected. Then he went and then he found a way out. And this when he was still a teenager, 12, 13 years ago. Then he gave a wrong age and then more than 18, then he created Gmail account, probably declaring to his kid sister also. This is how you have to create a Gmail account. So obviously at that point in time, it was not there, right? So I was just trying to figure out what is different here. Is it that the consent record keeping is any more stringent in the Indian law as compared to GDPR, or what is it?
Ramesh, you have to paraphrase what Subraidu said because I could not hear it clearly.
So he is asking that the same minor we are talking about, sir. So his question is that in the Indian context, when you are talking about handling minors' data, that consent, how they are going to take what you have answered already. The second is that, is there any kind of difference in terms of record keeping? Because you need to maintain, right, that proof and etc. Its onus is on the data fiduciary. Is it something that different than what is already prescribed in GDPR, or we are missing something, is his question.
Yeah, I saw one word in the Indian law, Navi sir, which said verifiable consent.
Yeah,
But the
verifiable.
verifiable word is not used in GDPR. Is that word that is unnerving people outside and something?
Yeah. And also because we are talking of a fiduciary responsibility, not just a controller responsibility.
Correct.
Yeah. So definitely more responsibility is there for verification. And in India, if you see our DPDPA, apart from looking at the guardian giving a consent on behalf of the minor, in the case of a minor, the definition of data principle itself includes the minor and the guardian. That is, in the case of minor under DPDPA, there is no exclusive data principle kind of a role for the minor. It is a joint data. If you see that definition, you will see that data principle, the minor and the guardian will be data principles. That has got some advantages as I have discussed somewhere else. So, which means that the declaration of the name and identity of the parent becomes mandatory for the minor. Okay. Now, the minor, if he wants to avoid the parental consent, he has to declare himself as a major. So don't declare. So where is the question of identifying? That is where I said if the service itself is meant for minors, you cannot hide it. A person cannot say, I am a sixth standard student of such and such a school, but I am not a minor. So there are certain services where the minority will be presumed. Okay. So there the guardian will have to be there. Now, who is the guardian? Has he given his father's this thing, or some friend or some third party might have just lent the name? This also is possible. So even if the same form asks for a consent, somebody else clicks on that in a different email, it is possible that the real parent may not know. But in this Aadhaar linkage, that is not possible. That impersonation of the guardian is not possible. Okay. So that is feasible in India because that system is in existence. Okay. Now, as Sandeep Arya has said, definitely Aadhaar cannot be used for the private sector was one of the things which came out of that judgment. This is not Puttaswamy judgment. It is also initiated by Puttaswamy, but not the privacy judgment, but the Aadhaar judgment. But it said that government can make some specific laws under which voluntary provision of Aadhaar by the Aadhaar holder could be permitted, and in the banking system that has been used. Okay, so bank cannot demand Aadhaar, but a person can voluntarily give. And in the meantime, Aadhaar has introduced this offline authentication, and I think this virtual Aadhaar. I think that virtual Aadhaar is good enough. It is not Aadhaar, in my view. Though the Supreme Court judgment actually was did not take this into account. If you look at what I have written at that time, I had said once there is a virtual Aadhaar need not be considered as a full Aadhaar information. And secondly, if the authentication from Aadhaar is only on this binary response yes or no for different kind of parameters, there is no disclosure of information from the Aadhaar side. Okay, the person will be declaring only his virtual Aadhaar. Virtual Aadhaar can be changed anytime, so it is not loss of virtual Aadhaar or sharing of virtual Aadhaar is not a privacy problem. It's a one-time usage kind of a thing, provided people know how to use virtual Aadhaar. Okay. Right. Then secondly, as long as the Aadhaar is not just throwing away the information on the basis of a query, but only saying if you have said in the form that my name is Vijay Shankar, the other person, the Aadhaar will only say it is correct or incorrect. That's all. So if that is the way Aadhaar is used, there is no privacy infringement. But what the current leaked reports are suggesting is that whatever permissions have been given to banks for use of Aadhaar, maybe others may be given some kind of permission for this Data Protection Act. That is where I said you have to declare or create specialized consent managers who are dealing with minor consents, and then it may be possible for the government to permit them, like they have done banking institutions, as people who can provide confirmations of the age. Maybe banks themselves can do that as an additional service. See, today banks are doing services like insurance and other things, but this verification of age of a minor, particularly if the minor also has got an account in the bank, can very well be done by the bank. So bank can be made responsible for confirming the date of birth of the minor and the guardian. So maybe in the procedures, these are things which have to be discussed. Okay.
And I think one more question. Okay, this is generic. Any news on industry and government closed door meeting on 19th? Alok sir had asked, sir.
See, when you say closed door, you know who are there. That is the Facebook and other people. They are trying the government to actually reduce the age to 13 years, one, and then make it easy for them. And it is under their pressure that the government is talking of providing some concessions. Okay. Only the big tech is there. It is only if at all anybody could be aware of this, only Anirban will be available because he is in the closed door meetings of the ministry many times. Okay, but I don't think there is anything which has come out. Whatever we are discussing today, that Aadhaar may be used, is part of that closed door meetings. But I am sure that this will be a point of contention if the government does not frame the rules properly. Definitely the Supreme Court judgment will be held out and this will be questioned. Yeah.
Yeah, yeah. Great. Sir, going back on that same DGPSA, what we were discussing, right? Now, is that if we understand correctly, okay, whatever you said so far in our earlier discussions, that this is taking care of the other frameworks, right? Or laws or standards. For example, it is DGPSI implementation is going to make me comfortable with, let's say, GDPR implementation, DPDPA 2023 implementation, and let's say ISO kind of systems, what we are aware of, 27,000 to 27701. Is that right statement, right? And I'm looking at that answer from you that even if an organization has not, let's take a fresh organization, startup company, where they don't have anything related to this 27,001 or GDPR, etc., will it suffice? Will our implementation of DGPSI, would it hold good for them, sir?
I think it should. Okay.
Great.
The reason is the DGPSI is an aggregation of the requirements directly from the DPDPA angle. That is why we created DGPSI Lite with about 36 implementation specification, which is actually section by section requirement of DPDPA. Okay. So if any company wants the simplest form of implementation without creating an ISMS, PIMS, DGPMS, and other things, simply look at the compliance. They can go through this DGPSI Lite and just have documentation of each of these 36 kind of a thing. And then they will be in compliance with DPDPA 2023. Now, DPDPA at one point says there should be reasonable security. Okay. Now, when we say necessary and reasonable, we have to presume that there is a risk assessment. Okay. Even if it is not specified. So a risk assessment is necessary. And that risk assessment is based on the risks associated with the misuse or incorrect use of personal data, either collection, usage, or destruction, whatever is that. Okay. Now, therefore, that is inherent in the word reasonable security. Okay. Now, security, normally we talk of confidentiality, integrity, and availability. Okay. Now, you have in the back of your mind the framework like ISO 27001, which was created exclusively for CIA complex, requirement. Okay.
Absolutely.
The subject matter of data normally is the entire data of an organization, not necessarily PII and non-PII. So ISO 27001 can be applied as a framework for ensuring the confidentiality, integrity, and availability of any kind of information. You can apply it to personal information also. So therefore, when we are talking of reasonable level of security, you obviously have a reference point of how to have access control, how to ensure that access is only given on a need to know basis. How do you have data storage security, whether you should encrypt it. If you are using a cloud, that is also part of data security. If you are transmitting the information, transmission security, preventing the malware, patching, all these common aspects of information security are part of DPDPA requirement. And therefore, when one of the implementation specifications, we say that confidentiality, integrity, availability of personal information should be ensured, we are already telling that these are the things to be done. Therefore, ISO 27001 has already been integrated with this. Now, if you go to 27701, you are having the privacy related obligations like legal basis, establishment,
Correct.
consent, and the rights management, okay, access rights, etc. Now, that will be covered in DGPSI. A small difference is that GDPR is meant for EU data. dgpsi is meant for Indian data. These two are totally different in an organizational setup. And the rights issue is different. See, obligations more or less is same. Data minimization, data retention minimization, purpose orientation, consent, informed notice, all these things are common. Okay. However, when we come to the rights, we have got here right to access, which is also there in GDPR, right to correction, which is also there in GDPR, but right to portability, which is there in GDPR, is not required here. Right
in India.
to forget, as different from right to erasure, is not mentioned here. Okay. Now, if you want to say right to erase, also includes right to withdraw the consent, also includes right to stop processing. Okay.
Right.
Which means that some of the rights which we actually list out in GDPR, they can be imputed into the purpose-oriented processing and the rights which are available for correction and say erasure. Okay.
Yeah.
So, but there is another thing, grievance redressal is a right here.
Correct.
Nomination is a right. So, two rights have been removed, but two other rights have been implemented. So, to that extent, 27701 will be inadequate to meet the this requirement. Even if you substitute the GDPR data with the Indian data in 27701, somebody may say, I have implemented 27701. At that time, I did not distinguish GDPR data and Indian data. I have included everything and I have a certificate of 27701. Still, I will say it is not adequate because 27701 auditor would never look at nomination. He will not look at grievance redressal as a mandatory requirement, as rights kind of a thing. He will look at things which are not here, which is an excessive requirement. Therefore, 27701 is not fully compatible with this particular thing. In fact, this DGPSI is actually encompassing many of the ISO 27701 requirements. A few it is not encompassing because it is not required for India. But what we have done in DGPSI full version is
Beautiful.
that you need to have a classification system in which the data classification should include the jurisdiction to which it applies. So you must have a distinction of GDPR data and Indian data. And then in DPDPA, there is a provision that if you are processing the data of foreign nationals under a contract with somebody outside India, then you can get an exemption from DPDPA. So having this segregation helps you to bifurcate your data into one which comes under GDPR for which DPDPA is not applicable, and another for which DPDPA alone is applicable. Now this GDPR said, if you want, you have a separate 27701 audit or whatever you want. The DPDPA auditor may say that this data is not coming under the applicability of Indian Data Protection Act. So I don't want to add it in the DGPSI audit. Ramesh, are you getting this point? So,
yeah, that's excellent.
So why should I take it unless you give me an additional contract? You also do a GDPR assessment. I may be capable of doing that. I may give it separately. At that time, I may use 27701 formatting itself. Okay.
So that's where I'm coming to. Excellent bullet, sir. Now, if my understanding is right, okay, right now we are talking about that I'm taking care of that entire Indian law. Say, for example, data portability from the GDPR perspective may not be applicable here for me. However, can I conclude that going forward or something, this DGPS also could be customizable to accommodate these kind of minor changes so that this framework is going to be a kind of robust framework covering?
Our framework will say rights of the data principle to be protected, something like that.
Right.
There
is a separate chapter.
So there we can add the other rights which are there in GDPR.
Right.
And expand this so that you can have the DGPSI auditor certify for the controls required under GDPR.
Excellent.
So you can extend it so that you can actually fully eliminate 27701. You can say DGPSI hyphen DPDPA, DGPSI.
Correct.
You can do that.
I'm coming to that point saying that I put the question this way now, sir, that I'm going to implement DGPSI and I'm giving that kind of enough confidence to the organization that, hey, look, you don't need 27001, you don't need 27701. Without that, my lighter version, the 36 shell components, is going to build the system for you, which is equivalent to your DPDP implementation. Having said that, assume I'm successful with the FDPP certification program in 6 months, 1 year time, right? Can I take this system now based on, let's say, later a business context? I need to go for 27701. Will that system help me? Vice versa, is it true?
You may not call it as 27701 certification because DGPSI auditor may not be authorized to give a 27701 certificate.
Fair enough. No, I will go to DNV.
Equivalent, I can definitely do.
Yeah.
My policies, I will be adding 2 more policies. I will be removing 2 policies. I will be adding 2 more policies.
Sure.
Nomination policy I will remove. I will add portability policies. So, but all will come under the rights of a data principal or the data subject. I may use the word subject and controller here. So the principles are same. It can be customized for GDPR, not only GDPR.
Yes, any program.
And other laws also are there. So in the recent last 1 month itself, we have received some queries for Philippines law, Jamaican law.
Bangladesh.
I can structure this for that, but that has to be done as a additional module kind of a thing.
Great. Subrayed sir, can I request you to come online? Now, is this making sense, or what we were discussing this morning? That DGPSI is capable of handling our DPDPA, GDPR 27701. Are we on the same page now, sir?
I'm trying to figure out, as you rightly took that example, if there is a startup which is not ISO 27001 certified as on date,
correct,
and it is going only for DGPSI, for example,
right.
Okay, then here again there are 2 questions. Does it go for DGPSI Lite or does it go for the full DGPSI is the question.
Right.
Let us assume for a moment as a matter of natural progression, it will go for DGPSI Lite only to begin with. Right. In that case, what I'm understanding is that it will still be compliant with DPDPA. Right. Supposing tomorrow, like let us say the under reasonable security practices rules or something, some equivalent comes up, and they say that ISO 27001 certification will be deemed to be compliant to reasonable security practices.
Right.
In that case, will that organization will have to move from dgpsi Lite to the full-fledged dgpsi, or will it still be compliant with all with dgpsi
Excellent.
Lite alone? Will it be compliant? That is one more question that I have.
Yeah, very good. Sir, you got the question now, sir, Navi sir?
No, no, please repeat. I've
So,
just put on this headset. I think now I'm able to hear him better. Yeah, tell me.
Subraj sir, shall I go ahead or you will only ask the?
No, no, please, you
Go
please.
ahead.
So his question is, as we discussed that, like my question is DGPSI, right? Without having any framework, any standard 27,001, I'm implementing it. Superb. I got successfully the certification of DGPSI by FDPP authorized. Now, situation comes to me from the business perspective that I need to be, let's say 27701 certification also, some, potential customer. Can I use this DGPSI which has been certified to
No, no, please wait. Now, 27701 certification for what data processing? Is it for Indian data processing?
Yes.
Then you should tell your client that no, it is not necessary. You are not understanding the 27701 is applicable for GDPR, not for Indian data. So I don't want to apply 27701 for Indian data, for which I have already made it compliant with the Indian law called dgpsi, because the client is ignorant of the difference between 27701 and this. That's a challenge which you as a business manager should sort out. See, otherwise, how can you apply what is not applicable and give a certificate also? Are you not misleading? Say, for example, if I apply only 27701, I will not worry about nomination. I will give you a certificate, okay, about portability and other things. It is non-compliant with Indian law. It is not correct, okay. But if it is for EU law, then I will say, yes, I will give you a 27701 certification by an authorized person, okay. Then I will also say that you please segregate this, have a separate, say, database or something like that. And like we do in HIPAA and various other cases, we actually create a hybrid entity, a concept. In fact, that is one of the principles we use here. So you create this as a hybrid entity, GDPR process center, Indian data process center, and then use your 27701 auditor for the GDPR data processing. Then you will be true to what is required. Then you will be conforming with the requirement of GDPR without the DPDPA coming in the way. I understand your business problem, because a powerful vendor or client is asking for 27701 without understanding that, like today, many people ask, I want HIPAA compliance. But if you ask people what are they doing, they are an Indian hospital working in India. Now, HIPAA can only be like a standard, reference standard. But certification of HIPAA is not necessary. You have to look at what EHR guidelines or Indian law is there. Now, of course, DPDPA is there. So this distinction, I think, it's a transitional problem. We have to make people understand. Like you go to a EU country, you cannot say, I will have a DPDPA compliance for a database which is lying in EU. Is it not? They will not accept it. Okay. Same thing should be applied here.
Both Navi sir and Subraj sir, I have a point here. I don't know how will I put it. Navi sir, are you trying to say now, because the question comes from my mind now, 27701 from ISO, okay, what they say as I start, it's a generic standard. It is for establishing the Privacy Information Management System, simple, PIMS. Incidentally, that Appendix D of that standard refers to GDPR. For the time being, for our discussion, if you take it out, my interpretation of the standard is I can use that to establish equivalent, what you call certification for deep.
No, idea that 27701 modified is dgpsi.
Excellent. That is you and me. I understand. But what I'm trying to ask you, is that the current 27701 2019 standard, can I not implement it successfully to implement my DPDPA 2023 also?
With modification, you
there
may
you
have
are,
to
sir.
do
In
it.
any standard, we need to customize it.
Correct. But you have to add these two additional rights.
Yes.
You have to remove two additional rights which are there in GDPR. You should look at the duties of the data principle.
That's exactly
notice form is different. 22 languages is not required. So you make all those changes, then that becomes DGPSI only.
Maybe what we can do is, what we can do is, if a company is 27701 compliant today,
yes,
this is what you have to add, this is what you have to subtract in order to be DPDPA compliant. That list, if we publish, that would be useful.
Subride, sir. And one more thing, the data on which you have applied 27701.
Yeah. This is one of the additional bias. The classification, I got your point. Your classification must be segregating the GDPR applicable data versus the India DPDPA applicable data.
Subride, sir.
Plus that you have to do.
Okay. Subride, sir, that's exactly we are going to do when we are arriving at statement of applicability. Now, both the standard of ISO is very, very generic to say that it's not that you need to look at only the controls of Annexure A of 27001 or the Annexure controls of 27701. It is giving you the kind of provision to look at. That's where I wanted to look at even DGPSI as one of the framework where I will bring in those controls as part of my statement of applicability if I am the 27701 organization at this point of time. If not, what I started with my original question, that if a startup company does not have anything, I'm starting with DGPSI, still I can do that with DGPSI. I will implement all the 50 controls of DGPSI. Plus, in the statement of applicability justification document, I will add the components of 27701 also if DGPSI is not having it at this point of time. So I'm sure that DGPSI allows me to customize it and bring out my own statement of applicability 2023, or it could be GDPR, or it could be DIFL, etc. So that provision we have, I think, as part of DGPSI. Am I right, Navi, sir?
In DGPSI, we have got this implementation. Just one second. I will just complete this. So in DGPSI, we have got the implementation charter. We have got a deviation justification document. Right. Now that is exactly what is statement of applicability.
There you are.
But here we are saying this deviation justification document has to be signed by the top management, not by the DPO. Okay, I want the organization to take responsibility for not including something or including new things, etc. Because that's a question of modification of the risk. So that risk absorption decision has to be of the management.
Yes, sir.
Okay, so Ramesh, statement of applicability, does it always get signed by the managing director or CEO of a company?
Okay. At this point of time, the CISO signs, sir, like a local information security. Yes.
I am saying that I don't want DPO to take that responsibility.
I'm with you.
This is a question of management taking the risk absorption decision. It has to be taken by the CFO in consultation with the CEO, because CFO has to then work on the insurance and other things.
Yes.
Okay.
Great. Now, Ashok has raised a question. Ashok, sir, please go ahead, sir. You have a point.
Yeah, sir. I think the fundamental thing, I'm talking mostly from a business standpoint. So there are two things. One is, Navi sir has already mentioned that for organizations which are small or startup kind of thing, you have a DGPSI Lite.
Yeah.
Now the other thing is, if we are talking of 27701, the prerequisite is you have to go for 27001 first.
Absolutely.
So that itself is an additional step.
Correct.
For small organizations. So trying to say that we'll go directly to 27701 is not possible.
No, it is not.
So
it
instead,
is not. Super. Yeah. You're right.
Instead, it is better to tell them that we have probably a lighter framework which can be easily adopted.
Yes.
And then if you want to look at other reasonable security practices, then you have to anyway go for 27001 first and then 27701.
Excellent point, Ashok sir. Be with me. I had not raised to 27,001. Assumption is that obviously we are aware that it's a base. And based on that, 2770 is going to sit. So, Navi sirs, even if you look at the DGPSI framework basic concept, it is going to address the 93 controls of the current version of the 2022 standard, plus that 43 controls of 27701, plus he is talking about additionally BIS standard, plus GDPR, etc. Are we on the same page, Ashok sir? You are right. You are right. Okay.
Yeah.
See,
Yeah. So only
if
thing I'm trying to bring out in a very, very strong way in all of our minds is that DGPSI, you can straight away implement it even if you do not have any basic system in your organization. That's point number one. Point number two, once when you are successful in implementation, having gone through that, customizing it further, the justification document, what Mr. Navi sir talked about just a while ago, could be the base document to accommodate whether it is GDPR, whether it is CPRA, whether it is DFL, and so on. So we have a kind of robust and flexible DGPSI is what we need to be having that in our mind. Am I right, Navi sir?
Yeah. Before we get into the deviation justification document, we are doing a risk assessment.
Yes.
That risk assessment will determine what is India risk, what is GDPR risk.
Yeah, same.
And therefore, there itself it gets segregated. If the risk is only India risk, I would like to strongly tell the client, don't worry about ISO 27001 or 27701. DGPSI is sufficient because that is the risk which you have to manage. You can't manage a risk which is not there. Assuming that somebody else who doesn't know about this is expecting that. See, our clients also, they are not aware of it, and that's why they are putting a standard format. Okay.
Yes, sir.
Navi sir, sorry for interruption. In that approach, I just see one problem, right? Supposing we go ahead and advise the client, you are only India specific, right? So you don't worry about 27701 or anything or 2707. Please go ahead and implement DGPSI. Okay. Supposing he takes our advice. Okay. Tomorrow, when the rules come out, an equivalent of the reasonable security practices rules comes out for the DPDPA also. In that, if the rules say that what constitute reasonable security practices, in that if they say ISO 27001 shall amount to you adopting reasonable security practices, there would be a problem at that point in time, is what I'm foreseeing. At that point in time, they have to go
I accept your this thing, but the controls which we are having, that is presently some 32 to 40, okay, should cover your basic technical this thing, should cover ISO requirements 27001.
Yes.
So even if the rules say, they will say that they will not simply say that 27001 certification is required. They may say equivalent of that or something like that.
Agree.
Correct.
Then say like 27001.
And this 32 to 40 is like 27001.
Okay.
Correct.
We have, in fact, if you gone through that, I have tried to make it a bigger paragraph so that several things are included in that. So only if the numbers may be looking small, but it has multiple controls of the ISO. ISO may say something about transmission, something about storage, something about cloud as 3-4 controls. We might put all those things in one control. Okay. Yeah, Ashok, you want to say anything more?
Yeah, sir, I have a very fundamental question. I'm again coming from a business standpoint. So when we talk about DGPSI as a framework, are we also saying that it is a kind of certifiable standard? Because if we talk about GDPR, for example, it's more of a compliance statement that you are complying with. There is no certification other than somebody like ISO coming and saying that we take care of the PIMS, and hence that is something that can be addressed.
So let me, Navi sir.
Please. Yes.
Ashok sir, one thing is that as we all know, there is no formal certification for GDPR as of now. It is
correct.
Only
that is what I meant.
Yes, you're right. It's a self-compliance, number one. Number two, even with the PIMS, again, I do not know. My interpretation, I always put this point across. It nothing to do with the GDPR, in my opinion. It is a generic PIMS establishment standard. Only thing they had given a kind of link to GDPR, and hence people are thinking that it's GDPR certification. Fair statement to claim.
Correct.
Coming to DGPSI, obviously it is a certification standard. We are going to
Right.
give certification. FDPPI is looking
Yeah, I
at.
think that itself is a differentiator, is
Yes,
what I'm
yes,
trying to
yes.
say.
Navi sir, please go ahead. That's what I wanted to say.
Agreed. That's
Yes,
why FDPPI is the certification agency. Now,
yes.
FDPPI, will it get accredited with the DPB and other things is for the
Ah,
future.
yeah.
Okay.
So
And
to answer Subraidu's question, that if we are successful really, as we were discussing, to take this DGPSI as a framework to the DPB level, and if they mention, hey, like 27,001, comma, FDPPI is
yeah,
DGPS, it's a great thing to happen.
correct. Yeah, that is what we have to aim at.
Yeah.
Yes,
Today,
yes.
today, of course, we may not say that we are equivalent to ISO or whatever is that, but
True,
today
true.
there is no framework on ISO which you can certify a DGPMS system.
Yeah,
So at least we can say that we are, whichever, say FDPPI is a small organization, you can assume, but at least there is a third party certification which is being made available to this. Okay, so that is
yeah.
the first requirement. Yeah.
Great, great.
And I will just answer one more question here because we have already exhausted the
Sir,
time, I suppose.
Deepa's question, very interesting question,
No,
sir.
1 minute. I will come to Deepa. First, Rema Ramnath has said something. With
Okay.
respect to grievance redressal mechanism, is there any specifics that is expected out of the rules? Rules may say that you can have alternate dispute resolution or something like that. They may not go into the details. In our DGPSI expectations, okay, is that you should have a whistleblower concept, first of all, because this has to be linked to the incident management system. Then you can use ombudsman
Yeah.
and then mediation. Okay. Now, so if you are using ombudsman and mediation, that is, I don't think DPB can go beyond that because they will not ask for anything more, because if you cannot have negotiation and then say mediation satisfy the customer. See, we are talking of complaints between a data principal and the data fiduciary. And the grievance is, I asked for some information you did not give. That is the rights part of it. That if it cannot be satisfied under the mediation, then that will go to the Data Protection Board, which is a quasi-judicial authority. They will conduct an inquiry, and when the inquiry happens, they will only decide whether the data fiduciary has been compliant with the act or not. They are not going to, they may direct, suppose it is about giving the information, they may give a direction to the data fiduciary, please give this information to the data principal. So the grievance ends there. Otherwise, of course, it will go on the appeal. But the Data Protection Board is not going to give any financial compensation. But if the data principal wants a financial compensation, he can go to the adjudicator of ITA 2000. That also is a quasi-judicial authority. So therefore, the grievance redressal system will stop at mediation. Before mediation, negotiation, having an ombudsman, these are the things which can be tried. I don't think the DPB will go into the details of that. Basically, they expect you to have an adequate grievance redressal mechanism. If it fails, you have the DPB to take care of it. But if you are having a grievance redressal system with mediation, and also let us say it is open to arbitration, that system will be helpful in your resolving disputes between the sub-processors. See, when you have a business, the disputes will not only come between the data fiduciary and the data principal, but also between the data fiduciary and a data processor. Now, that is a business-to-business contract-based dispute, which can be taken care of by the grievance redressal mechanism which you have got, even at the level of arbitration. Because what we are talking of in the grievance redressal system for mediation is online mediation kind of a proposal, which I have been talking about it under odrglobal.in. Even FDPPA also, we are talking about the Data Disputes Mediation Center. That center basically will be having a video conferencing with all this paraphernalia of sending the notice, arranging the meeting, hearing, and other things, having a mediator, all these normal requirements of an online dispute resolution mechanism. The same thing can be used for arbitration if it is a B2B dispute, not this data fiduciary data principal dispute. That cannot be taken into arbitration because DPB will come in. You cannot take over the rights of the DPB followed by TDSAT and Supreme Court. That cannot be taken into an arbitration level. So I think that is what I would like to say. Then Deepa's thing, then if Rema has got any supplementary question, we will address it. Now what Deepa is saying is how data trust score can be applicable to data protection laws. See, what is data trust score? It is an evaluation of how good is the implementation of compliance. Okay. At the minimum level, we are saying that we are certifying that you are compliant with the law. But how good are you beyond the passing marks? Say if the passing marks is say 35, have you scored 45? Have you scored 60? That assessment is what data trust score does. It gives a assessment guidance to the management because this data trust score, what we have conceived, also recognizes that multiple divisions of an organization has responsibilities: management, DPO, legal, HR, IT. So this DTS system can give a kind of a idea about which of these divisions are doing are pulling down the overall data trust score, where more attention has to be given. So it has got the, apart from the consolidated DTS being an indicator of the overall compliance capability of the organization, individual division level performance can be an internal management guideline. So I feel it is an add-on to the certification of the audit. This is my view. If Ramesh has got something more, he can add.
I think I'm with you, sir. Mainly, as we are discussing, the 35 shell components, we need to have that criteria in which we assess, right? Auditing is different.
Wait. DTS today we are talking of only for the full this thing. 50 components.
Fair statement.
50, yeah.
Now we should also have that kind of provision to tell them that, let's say, and in my opinion, organization also, it's like a quality objectives goals, right? This is my goal, and this is the threshold I wanted to operate it. And based on that actual data, they continually improve, right? The same concept we need to have here, because you cannot straight away aim at, as we all know in the call. So I think I'm with you. It can be arrived at based on the, again, context of the organization, based on their immaturity of that, process, journey, and so on.
Yeah, Rema and Deepa, any supplementary questions?
Deepa.
Thanks, Navi sir and Ramesh. See, my question is, I am kind of aligned with you, but if it is an ISO 27701 series when we are doing, so there is no point of data trust score, right? We have not evaluated, or my auditor won't come back with that kind of a thought process, right? This is only in our FDPPI controls and the mechanism we introduce this. So how this can be extended for an other laws compliance?
Okay. Now you are talking of DTS for GDPR.
Absolutely.
Okay. Now, I say against this 50 implementation specification, if I am looking at a GDPR data, okay, where I have made changes as far as the rights are concerned or something like that, okay, still the same 50 is there also. Here, when we are talking of rights of the data principle, we are substituted with the rights of data subject, something like that. Now, how well the right to access, right to prevention of automated processing, etc., has been done, they all come under the right to right of the data principle, data subject, how well the company has managed. There, I can give my valuation. No, I can give 3, 4, 5, 6, 1 to 10 scale. Say what we have done in DTS is this 50. we have each of these 50, we are trying to evaluate from 1 to 10. And same way, if I am assessing it for GDPR also, I can still say whether it is 5, 6, or 7 for the control related to the particular say
So
item which is
yeah, sir. Net, then when we are customizing with an extension to it, what we discussed earlier, couple of questions, then we may need to relook at it even a DTS system also accordingly
Yes,
evaluated
yes,
for those
yes,
particular
yes, yes. Obviously, obviously.
yeah.
See, just to add, Deepa, now I understand ISO doesn't look at, okay, evaluating quantitatively, because audit they are doing, it's a binary. Yes, no. The
Mm.
requirement you have fulfilled, not fulfilled. If you are not fulfilled, you are a non-conformity. They're very simple. But that's why that many of the IT organizations are not very interested with the ISO kind of management system. Of course, they wanted to return the certificate, they go. What is interesting is that quantitative perspective, right? We all in that IT, we used to have capability maturity model, CMMI level 1, 2, 3, 4, 5. And today the same concept is coming into cyber security maturity model, CSMMI, they say, right? Based on this framework, any framework. So we can evaluate for your own organization based on that criteria, what we wanted to set, where you wanted to operate it basically, because you would
And
have signed a contract.
one more thing, this BIS standard,
Yes.
I think is making a reference to the measurability of the
Only
implementation.
two parameters, no, sir. Obviously, you are right. It talks about, if I'm right, two parameters it is talking about. One is at the,
performance.
one is at the entry level, and one is at the optimized level, right?
Yeah.
And it is very simple. You are just implementing it without having a documented process. Oh, you are operating at the entry level. Now I have a documented process. I'm implementing as per my documented process, and I'm producing that evidences related to that. Oh, you are operating at the proficiency level. That's exactly we are talking.
Say,
so
valuation and measurability are two parameters which we had introduced in PDPSI 2-3 years back and carrying it to DGPSI. Both of them are there now in the BIS standard.
Yes.
BIS standard is for data governance, and one part of the data governance is data protection.
Yes,
so,
absolutely.
About 25 controls come from there. We are saying DGPSI is already looking at this kind of a thing. Okay, we can have a separate mapping done for that 25. But the fact is that measurability of your compliance implementation and valuation of data both are, in fact, from our perspective, we were futuristic. 2 years back, we were talking about this. Even distributed responsibility, we were talking of a futuristic concept. Now the BIS standard and others are coming into that. Somewhere in the corner of GDPR also, there is a mention about measurability possible. It has not been mentioned as a requirement, but somewhere they have made a mention.
Okay, thanks.
Great.
To add on to another one point, sir, when you were explaining on the grievance redressal, when especially on B2B, yes, as you said, it is an arbitration process. Unless it is very clearly captured in the agreement between a data fiduciary and the processor, then it is only remedy is through your equitable remedy or court judicial system only, sir.
Yes, but you should incorporate arbitration, because even the DPB says that when you go with a dispute, they will ask you to explore mediation or alternate dispute resolution. It is there in the DPDPA. And even to civil court, the first thing they will ask is whether you have explored mediation. So it is better to have that as part of your grievance redressal, so that one step is completed before it escalates into a court system.
99% of the agreement, that's one of the standard boilerplate clause where legal team is trying to introduce it. But sometimes this get missed. Even if it is not captured from a judicial perspective, you still have an option.
Yeah.
So you can invoke a mediation and settle the process and file the settlement agreement in that and close. So
in DGPSI framework, it comes there as one implementation specification so that you cannot forget.
Yes.
Right.
So valuation comes there as a thing, so you cannot forget. You can consider, you can remove it from your deviation perspective, but we have put it there so that the management is told, oh, this is something that you have to think of. Likewise, grievance redress is something you have to think of.
Yeah, yeah. Okay. Thanks, Deepa. Manju, sir, we can close it, right? Because it's already another, yeah.
We didn't go through more than 2-3 questions.
Sir, I'll tell you, I have some 10 questions, not even third question I have completed. Expected this. I'm extremely happy at least that lots of, this is exactly Navi sir, as I said, right? We need to have this kind of discussions till this PDPSI settle down. I really wanted some technical person, okay, even amongst us that war is really to discuss that 30 to 50, the controls of Navi sir's DGPSI. Believe me,
Yes.
the 27,001 and 27,701 will sink in our mind in a very strong way, because we need to have that kind of accountability that, yeah, DGPSI is the framework. Okay. We all need to work together, in my opinion, along with Mr. Navi, then only it will take off. So we need to have multiple. That's why I requested Manju madam to put it as part 1, That means we all need to know, like Singham 1, Singham 2, Singham 3. We are going to have multiple series of discussions on DGPSI in the coming. Before I hand over, thank you very much, team, and wishing a Merry Christmas and Happy New Year 2024. We all will work together to make FDPP and be successful in the coming year. Thank you. Now, Madam, yours, Manju. Thank you.
Thank you, Navi sir and Ramesh ji, for taking us through the nuances of DGPSI. And with